What if privacy wasn't just about data, but it was about dignity, trust, and the kind of society that we want to build? I'm Amy Yee, and this is Wired for Change. Today, we're going to look at some of the biggest organizational struggles when it comes to privacy and why it's more important than ever in a technology-driven, rapid change environment that we're living in right now. I'm thinking that this is really going to be a great episode, whether you're starting as just an innovator or an entrepreneur in the space, or whether you're looking at system-wide change, this one is for you. I'm very pleased to be joined today by Dr. Sophia Muller, a privacy expert. Sophia, I've worked with before, and she is a delight to work with because she combines such deep expertise with very practical perspectives when it comes to meeting organizations where they're at. Sophia, thanks so much for joining us.
Thank you so much for having me, Amy.
Amazing. So let's get started by looking at just the landscape and thinking about, given that this is Wired for Change, what's changed and what hasn't changed in terms of privacy, just to help us all level set.
Oh yeah, absolutely. So there's obviously a lot going on in terms of changes, societal changes, and how we regard privacy within that context. And maybe I'll take it back a little bit just to put it into broader historical context, right? Privacy, when we first started looking at it as a subject of law, was really grounded in the idea of like territorial privacy, right? That you needed a warrant or a justification to enter someone's home in order to effectively come into their personal space. And that's evolved so much. You know, when you look at like the Second World War, for example, a lot of our concepts of privacy that we have today as a modern society are actually grounded in the atrocities of the Second World War, where we saw the harms that could come to individuals in circumstances where you've got mass data collection, surveillance, and then the mobilization of tyrannical objectives, leveraging that information, right? So coming out of the Second World War, we have a much more fulsome and enriched understanding of the importance of privacy and what can be done if personal information falls into the wrong hands. So on the onset of the Second World War, you have this concept of privacy as being a human right, as being a matter of dignity, as you noted, and as also being a very important and powerful tool that individuals need to retain in order to exercise a measure of autonomy and agency in order to determine when it is that they're going to be sharing their personal information, under what circumstances, and to what end.
That's interesting. How real was it at that time? Because you didn't have a lot of electronic sharing of data or personal data, for instance. So what would be an example that would apply, like coming out of the Second World War, as you said?
Well, there were computational capabilities in the Second World War, and there was also the mass collection and systematic collection of people's personal information, dividing them into religion, ethnicity, political beliefs, and then leveraging that systematized collection of information, again, to very tragic consequences, right? When we think of the concentration camps and the internment of Jews, political prisoners, people with disabilities. So all of that to say, like there was a weaponization of personal information against individuals. And that really brought about the idea that these strong privacy rights are indeed really foundational to a liberal democracy. And they're a cornerstone of fighting tyranny.
I never really saw those historical events from a privacy lens before, so I appreciate that, Sophia. Thanks. And then, so where do we go from there?
So in terms of where we're going from there, I mean, we have obviously the computational turn in pretty much every aspect of our lives, right? And we're now at a point where we are ubiquitously generating data in terms of our online interactions. You know, it's difficult to exist now in this day and age and not generate additional personal information about yourself, right? And on top of that, we're also entering an era of, again, questions in terms of how does that data get monetized? How is it leveraged against you? And I think there's a turn also where it's not just about governmental authorities and what they can and can't do with personal information, but also a turn now to what can private industry reasonably do with your personal information, right? So what's really interesting is that we often hear this refrain about, privacy is dead in virtue of the fact that there's just this abundance of personal information that's being generated. Right. But I think that really doesn't capture the nuance around privacy, which is precisely about choosing what information we provide, under what circumstances, and how it gets leveraged, right? And that's supported actually by a really much broader understanding about privacy and concerns that we're seeing amongst Canadians right now. In 2023, for example, the OPC actually released a report and research that it had conducted. And in the survey, 93% of Canadians actually expressed concern over their privacy.
Interesting.
Yeah, so this is very much at the forefront of people's minds.
It's so interesting because sometimes in a debate, people will always throw out, examples, and this is the kind of organizational struggle that I talk about in organizations because they're thinking, well, does it really matter? How concerned are people actually? And I guess it's contextual as well, right? And then how much do people even know about what could be done with their information versus what they see? If you're not an expert in this field, or if you're not somebody who works in marketing typically, or if you're not someone who ever leverages data, are you aware of the extent to which your data could be used?
That's a brilliant point. And again, that's further supported by additional research that was published by the OPC, where there's about 40% of Canadians believe that businesses respect their personal information and their privacy, right? That's really low. It's actually technically just under 40%. It's like 37%. So it's definitely at the forefront of consumers' minds. And I think as we're kind of looking south of the border in terms of what the political context is there, I think it certainly helps to further underscore sort of the hyper-awareness that Canadians have regarding personal information practices for products that come from the United States and their ability to conform to Canadian privacy standards, particularly when we start talking about more advanced technology such as AI.
Okay. So in terms of what's not changing, privacy is important.
Exactly.
Right?
Yeah.
It remains important. So what are some of the things that are changing?
So it's interesting because a lot of the changes I'm going to refer to are actually sort of some of the tensions that new legislation is trying to address. But it's precisely that ubiquitous generation of personal information. So the idea that we are now generating a lot of personal information in our online interactions, in our day-to-day work, and in our personal lives, right? And how that personal information gets linked is something that I think is very new to us. And the extent to which, again, that information can be mined or leveraged to ends that we had not anticipated is very interesting, right? Because there's undoubtedly the potential for a lot of good to come from it. But at the same time, if you're not soliciting the appropriate consent and providing the appropriate notice to individuals to make those decisions, that's how you lose trust foundationally, right? And I think for consumers, because of the onslaught of all this new technology and a certain level of awareness, there's a real challenge in being an informed consumer and being able to make that risk assessment, because our current privacy regime is really very much predicated on the notion of consent, right? You consent to provide your personal information in exchange for a product or service, and along with it comes like a privacy notice, right? And how many people read those privacy notices? As a privacy professional,
Was that not part of the OPC research?
it was. There's actually a lot of research around this, and that's why the OPC has really been pushing this idea of meaningful consent. But nonetheless, that the onus is placed on the individual to conduct that risk assessment and to be hypervigilant about the use of their personal information. And in this day and age, that's a Herculean task, and it's very difficult to keep up with it. And I, as a privacy professional, struggle to keep up with it. I can't imagine what it'd be like not to be privy to sort of all the risk assessments and understandings of harms.
Well, knowing you as I do, Sophia, if you can't keep up with it, I don't think there's much of a chance for the rest of us. But I think that's a really interesting point. And, due to the computational power that is available now to make those linkages and to do things on the other side that you might not have available to you as a consumer, and just thinking about kind of the balance of that, because your ability to understand what can be done. I mean, it's not that there's like one person in marketing over there who's connecting the dots, right? In terms of, oh, there's Sophia and she bought this and she's experienced this and here's what she's thinking about. It's massive computational power and tools and platforms that are out there that are able to mine that data and information.
Absolutely. And also the data sharing, right? The data sharing. So, I mean, affiliate and marketing programs are actually really good examples of this, right? Rewards programs where your information is being shared with a number of third parties. Some of it certainly to your benefit.
Absolutely.
But like, how are you able to reasonably weigh the benefit versus the potential drawbacks of your information being shared?
It's that potential, right?
Yeah,
It's the future kind of uses of it, I think, that go past like maybe that initial use case that you may even consent to, right? How do you know?
exactly. Exactly. And then how do you, if you as an organization have obtained consent for a particular use of personal information, now you're going to have an obligation to make the estimation of what the delta is with regard to this new use of data,
Hmm.
and whether or not you need to go back and solicit further consent.
Or take away your consent, which is something that you can do, isn't it?
Well, you as a consumer could certainly choose to withdraw your consent, but that presupposes that the organization that you've shared your data with has mechanisms in place to effectively do that,
Mm-hmm.
right? And I'm sure, as we'll get to a little bit later in our chat, that is very much the tip of the iceberg in terms of your data governance programs and your overall level of maturity when it comes to consent management and your records, maintaining an active records of processing activities inventory.
Amazing. And again, not trying to be alarmist here, but I think we're just trying to bring a balanced perspective to what the situation is and what the landscape looks like right now, because it's evolving. And I think it's easy to make assumptions about, organizations and how responsible they are with our data, and not through any malintent necessarily, but this is something that's very much evolving.
Absolutely, absolutely. And I think it's what's really important about that is that it's not about being a Luddite and saying nay to new technologies, but it's rather about having a balanced understanding of what your obligations are as an organization vis-a-vis your employees and your clients and your prospective clients and members of the public, and how you can integrate privacy requirements to build trust and be compliant to existing Canadian privacy legislation and regulatory expectations. So it's certainly not a zero sum. It's about using that knowledge about privacy to maintain that trust and also to improve your overall user experience and your products.
Mm-hmm, mm-hmm, absolutely. And so let's go to another organizational struggle. I think even before you're setting forward your requirements, for instance, before you know all of that and you've got it fully fleshed out, I think some organizations struggle even with the idea of, if I don't handle social insurance numbers or health information, I'm not dealing with personal information. Like just knowing what they're dealing with and how sensitive that is can be a struggle for organizations. Any thoughts on that?
Oh yes, yeah, I have a lot of thoughts on that one. But it is actually a refrain that I hear quite frequently, right? And I think, like, in fairness to those organizations, there's a common understanding of what personal information is, and then there's like the technical understanding of what personal
Okay.
information is. And maybe I'll just dive into the technical
Sure.
for a moment, because I think it helps to elucidate sort of some of the blind spots. So the definition of personal information by and large in Canada is information about an identifiable individual. That is fiendishly broad. and I say that because if we break it down into further components, information is very broad, as you can imagine, right? Like it can be factual information about an individual, it can be inferred information about an individual, it can even be fictitious information about an opinion about an individual, or even a matter of opinion.
Wow.
Right? It can also be behavioral data, right? So the rhythm of your fingers on the keyboard, the modulations in your voice, these are all things that you can attribute to an individual. And so that
A
information,
much broader definition than most people would consider.
absolutely. And it's not to say, personal health information, social insurance numbers, unique identifiers, those are all part and parcel of information. But the idea is that, like, it is so much broader than what I think we, in layman's terms, tend to understand personal information as, right? Because we kind of hyper focus on the things that we're most concerned about protecting and safeguarding. So it's so much broader. Now, when we switch over to the other half of that definition about an identifiable individual, that's also a very elastic clause, right? Because the identifiable individual doesn't necessarily have to be first name, last name. It could be a unique identifier, right? It could be your employee number. It could even be your IP address.
Okay.
So the idea being that you can take information and attribute it reasonably to an individual.
Okay.
And that gives us the universe that we have to consider when we're talking about personal information at large.
Okay. And so then what does that mean for me as an organization?
So in all likelihood, you're handling personal information and you will have to comply with some form of Canadian privacy laws, right? For organizations that do B2B manufacturing, for example, you're probably not out there collecting a lot of information about clients, but you do have employee personal information that you are responsible for handling appropriately and in conformity with those legislative and regulatory obligations, right? So it becomes about how are you handling employee personal information? To what extent do you have surveillance mechanisms in place that you've provided sufficient notice about? What are you looking to do with that employee personal information? Does it meet their reasonable expectations of employment? Or are you doing something a little bit funkier with it where you're looking to monetize? And if so, what notice and consent have you solicited from that, or from your employees? So and can you even do that in the first place, right? So all that to say, most organizations are handling some form of personal information. Their obligations and the extent to which they have to engage in active risk management activities is obviously, again, flexible and responsive, to a number of considerations, both in terms of the jurisdictions that they operate in, the volume and scope of personal information they handle, the inherent sensitivity of that personal information, and then how they intend to use it.
Okay. And so at that point, do they start to triage and engage a privacy professional or their own privacy team?
Absolutely, yeah, and you can certainly start with your internal privacy team, if you have one. And if you don't, I highly recommend just speaking to a privacy professional, so at least you get a feel for sort of what your risk surface is when it comes to your personal information handling practices at large, and a solid understanding of what your obligations may be.
And then determining your policies after that as well would be a key piece in your legislative requirements.
Absolutely, and those policies, the privacy program goes a lot deeper than the policies. The policies are very much sort of the surface level component, a very important but nonetheless surface level component. But you're also going to have to account for risk management activities, right? And that's everything from your third party and vendor due diligence processes to completing privacy impact assessments if you're obligated to do so. And then also managing the remediation efforts that may come out of those risk assessments as part of like that data life cycle, and also your project management life cycle.
Okay, great. Thank you. I'm going to move on to another organizational struggle now, I think.
Yeah.
I think this one comes from sort of not having a clear definition, I think, between privacy and security. And you and I have worked together on teams that have figured it out. But not every organization has figured it out and how to manage and how to have privacy and security work together. I think a lot of executives have it in their mind that they're not the same thing, but I don't know that they would be able to articulate how to use one versus the other. Do you have any tips on that?
Absolutely. So as a starting point, and I think very intuitively, obviously privacy and security go together, right? It's very difficult to safeguard personal information without a robust security program. But in merely having a very robust security program, it does not guarantee that you will be able to comply with your privacy obligations, right? And if I kind of think about it as a Venn diagram, right? And on the topic of understanding what data you have, the sensitivity of it, and how it needs to be protected in terms of those organizational, technical and physical safeguards. Perfect overlap between privacy and security. Where they diverge is really around these questions of the scope of personal information that you're collecting, what your legitimate purpose for the collection of that personal information entails, how you intend to use that personal information, the consent and agreement that you have with your data subjects in terms of the conditions under which they have agreed to provide you with their personal information, and then also the exercise of individual rights, such as access to their personal information, the ability to correct it, the ability to request deletion, the ability to request a copy of their personal information, and with Quebec, we also have the ability to request portability of your personal information. So those are things that are not going to be addressed as part of a security program that would be very unique to a privacy program. So it's very important to have that as a solid complement to your security program at large.
That's really helpful, Sophia. And just to go a little bit further into those rights that people have, and some people are very aware of them and some people might not be as aware of them, given that they're enforced to different degrees depending on your jurisdiction. Where does that come from? The right to, for deletion and modification. Does that come from a demand? Like, do we know that there are a lot of people asking for that? Is this a specific industry or use case? I'm just curious.
It's a really great question, and I think it's a few things, right? Coming back to to our opening discussion, it's very much about putting the individuals at the center of decisions and allowing them to exercise rights as a measure of counteracting or mitigating, I should say, certain power asymmetries that exist, right? So how do I hold an organization accountable to their personal information handling practices? Well, the best I can do is to request a copy of the personal information they hold on me, to request further information about some of their processes and their activities regarding the handling of my personal information, transparency regarding which organizations they're sharing that personal information with and to what end. And then also the ability to correct personal information, right? Like we see that inaccuracies to personal information can result in very real harms. Like just think about credit monitoring, for example, right? And credit bureaus.
That's a good one.
Yeah, I mean, credit monitoring and credit checks appear in a myriad of places when it comes to automated decision making about determining the suitability of a job candidate, right? Determining the suitability of somebody if they're looking to rent, rent an apartment from you, and also as part of like security and background checks. And if there are inaccurate pieces of personal information related to that, it's going to put you at a disadvantage potentially, right? So your ability to request what personal information an organization holds about you is basically an opportunity to flex some of those rights and take back some of the power to say, do you even have the right information about me if you're making a decision about me?
I love that, Sophia. And thanks for answering that question so well, because I think that it's helpful to have people be able to connect to the why around that so that they can be more aware of their rights and actually do those things when they need to. I feel like I grew up in an era where I just took for granted that people held all kinds of information about me, and some of it's right and some of it's wrong, and I don't really have, any power or any say in the matter. And so I think this is a very helpful kind of evolution and discussion. So thanks for that.
Yeah, absolutely.
All right, the next one I wanted to move to is something that we discussed a little bit before, and it's the idea of privacy risk and policies. And an organization thinking, well, I've got the policies in place, that's pretty much all I need, right? Maybe you could take us into that a little bit more.
Absolutely. So I do see this. This is a very common, sort of a common pitfall that organizations fall into, where they want to do the right thing. So they write these aspirational policies, and these aspirational policies are not reflective of their reality when it comes to their overall maturity of data governance and the personal information that they hold. It's not always reflective of how they use the personal information, and there might be some serious impediments, like structural impediments, to your organization that prohibit you from fulfilling what it is that you've put in policy. So when we talk about policies, I'm always quick to say to organizations, I love that you want to rewrite your policy on AI, or I love that you want to rewrite your employee policy or your employee personal information policy. But what are you actually doing? And what are you doing well? And where are you falling short? And how do we capture this in a way that is accurate and transparent to individuals? Because first and foremost, your policy is supposed to be not just your guiding light, but it's supposed to be a clear articulation of what you do and don't do as an organization when it comes to personal information handling practices, right? So that means you have to have a very strong command of how you currently leverage personal information in your organization. If you're updating a policy to adjust to a new regulatory finding, or you're updating it to adjust to new legislative expectations,
Or maybe it's a client requirement, for instance, as well.
Absolutely. Yeah. Or clients have expressed sort of dissatisfaction around a certain practice, and you as a good organization want to be responsive and respectful, then you do need to capture that in your policies. But what emanates from those policies are your day-to-day practices. And without understanding what your day-to-day practices are, your policies fall into the trap of potentially becoming aspirational as opposed to reflective of your practices. And the same is true, interestingly, of privacy notices, right? So we refer to these commonly as like privacy policies that appear on the website that let everybody know how an organization uses your personal information. But the core requirement there is that it's transparent and that it's accurate. because coming back to that individual consumer, that's one of the seminal pieces from which we can actually glean how an organization uses our personal information, which in turn allows us to determine whether or not we want to grant our consent for them to use our personal information.
Okay.
So that transparency requirement, it's not worth anything if it's not accurate.
I see. I see. That's helpful. And then what about, organizations that, may not have the time or resources or expertise and are looking to, borrow or reference or be inspired by existing policies or policy templates that they can just sort of adopt and maybe adjust or configure for themselves? Any advice for that?
Absolutely. So regulators have some really good, in particular the OPC has some really good guidance around how you ought to draft a privacy policy, right down to recommendations in terms of just-in-time notification, the level of complexity in terms of language that you should be using. So please do not use like legal jargon, for example. But I think, even with the best of templates, you don't get away from doing the heavy lifting in terms of understanding what personal information are you collecting, under what circumstances, and to what end, and what are the do's and don'ts in terms of how you're going to leverage that personal information, right? So it's an organizational know thyself moment. Like you simply cannot get away from that. So for sure, there's some great tools and templates out there, but you can't just rely on those tools. You've got to do the heavy lifting.
And then part of that know thyself, that you were talking about connects back to the risk management side of things.
Precisely. So those policies in turn have to be supported by really strong pillars of risk management, in particular privacy impact assessments. We mentioned briefly vendor due diligence activities. There's ongoing monitoring and testing that you need to undertake in order to confirm that your various business units are indeed operating in conformity of the policies you've set. So there's a lot of fact checking and risk assessment that goes into underpinning those policies that are your guiding light and your North Star.
Great. And then for organizations that are just starting out, when do they really need to do a privacy impact assessment?
Oh, you can tell I get this question a lot. So the privacy impact assessment itself is really like a collection or a capstone to a number of activities, right? And so when people come to me and they say, well, I'd like to have a privacy impact assessment, I'll usually turn to them and say, well, at what stage are you at in terms of your overall project? Okay. Right? And what I really recommend is the sooner the better. The sooner that you can bring a privacy professional into the fold and you can start just going through ideation. Okay. Right? Like blue sky thinking with a privacy professional in the room, it really helps you circumvent a lot of pitfalls that, like for example, if you're thinking of like, can we even do this? Having a privacy professional in the room to say, well, what is the accuracy of our data? How can we effectively leverage this data? And what are the parameters on the appropriate use of data? What would we need to do in order, if you wanted to do X, Y, and Z, what would we need to do from an A, B, and C compliance perspective, right? So having that privacy professional in the room to work through the ideation, to work through the upfront requirements, to work through whether or not this falls within your overall risk appetite as an organization, the earlier the better. And having, in an ideal state, you have the privacy professional accompany you throughout the entire project lifecycle, right? So they'll work with you in terms of articulating your vendor due diligence requirements. They'll help assess the vendor. They'll provide recommendations on what some of the risks are. They can proactively identify mitigations in order to prevent you from having to be beholden to certain risk pockets. So having them involved as early as possible is great. And really, out of that engagement, you eventually get the fully documented privacy impact assessment. And the idea behind that is being able to identify risks as early on as possible, communicating it to your technical colleagues, and then allowing your business and technical colleagues to remediate those proactively, as opposed to waiting till the very end for a formal PIA to tell you that you got something wrong in step 2.
Absolutely. And this actually leads really well into the last struggle I wanted to talk about, which was around agile solution development, right? And really having them, there at the beginning helps you iterate and test. So for people who might think that, well, having privacy programs is expensive and it doesn't work with an agile kind of process for solution design or an agile mentality, what would you say, for that?
I would say, the extent to which you need to have your privacy resource involved very much depends on, again, on the scope of personal information that you're handling, the inherent sensitivity of that information, and how you intend to use it.
Mm-hmm.
Right. And so if you're in a project that's actively looking to maybe utilize client personal information, and you want to start doing some really interesting marketing initiatives based off of like a collection of behavioral data, I highly recommend having your privacy officer or your privacy resource embedded as early as possible as part of that ideation process. If you're looking to undertake a project that doesn't really involve much personal information, then for sure it can be more of a touch point. Mm-hmm. Right. But again, the earlier the engagement, the better, because the worst thing that can happen is that a project team is very excited to go down a certain path, and then for the privacy officer to step in and say, on second thought, we really can't do that. Mm-hmm. Right. So the earlier, the better. And again,
it's not fun for anyone.
No, it's very disappointing, and it feels awful, right? Because it basically takes away your ability to have that risk-based discussion up front, mm-hmm. and again, mitigate those risks effectively for the organization at large. And it's frankly like if you're waiting till the end to engage your privacy officer, there's a ton of missed opportunity and opportunity cost. Mm-hmm. In failing to engage much earlier, right? So yeah, I think that the key takeaway is that the level of engagement obviously depends on the sensitivity of the personal information, but frequent engagement has to be part of the equation regardless.
Mm-hmm. And hopefully you have those important discussions about your risk thresholds and risk appetite based on what it is, and that you know yourself going into those discussions.
Absolutely.
Great. Okay, so let's turn to the water cooler question. So this is a question I like to ask for the experts that I have on the show. If there was a water cooler where all the top privacy people were gathering to drink water or maybe have a glass of wine, what are some of the things that are top of mind today?
At the privacy watering hole, there's a lot. There's a lot going on right now. I think for Canadian privacy professionals, there's a fair bit of discussion around when will we get our replacement to PIPEDA. Mm-hmm. So our federal private sector privacy legislation. We had Bill C-27 that died on the order paper, shortly before the prorogation of Parliament. We now have a new government. Part of that government's platform involved AI. We know that we want to have greater entrenchment with a variety of markets, including Europe, as well as a number of Asian countries, all of whom have well-advanced privacy regimes in place and privacy legislation. So privacy practitioners are kind of waiting with bated breath to see what happens in terms of, are we going to revive Bill C-27, or are we actually going to push ahead with something that is a little bit more equivalent to how a lot of privacy regimes have evolved internationally.
And what's the next step that we're waiting for here on this point?
For the bill, for the bill to be presented. And what's really interesting is I attended a conference a couple of weeks back, and there's a Senator Deakin actually spoke to an audience of privacy professionals, where he kind of like lamented this very issue, right? Like we're falling behind as a country. Canada used to be pretty darn good, mm-hmm. From a privacy regime perspective, and our progressive attitudes around that, but we've since sort of fallen behind. We're obviously not going to go the direction of the United States, where there's discussions about deregulation. Like that is not within, the precedent that's been set, and certainly not consistent with, the OPC or even the new government. But we do have to sort of reinvigorate our work efforts around this. And I think one of the really interesting things that Senator Deakin brought up was precisely this issue of it's hard for legislation to keep up. Even where it's principles-based, mm-hmm. it's slow and it's difficult to keep up. And, can a pan AI privacy-related piece of legislation really do us justice? Or are we going to be looking at a bit more of a hybrid model that leverages standards? So standards around AI. Mm-hmm. So undoubtedly there'll be like a bedrock of principles that inform AI at large, but then there'll probably be, in his opinion, nuanced standards that allow the application of AI in certain sectors or to certain ends that might help be a little bit more responsive to evolving technology, right? Without sort of having to put it all into one piece of legislation. I have to say, I found that a very interesting idea. We'll see. We'll see if that's how they choose to tackle it going forward. But nonetheless, I think privacy professionals are sort of waiting with bated breath to see what happens at the federal level.
Okay.
Yeah.
Well, I'd love to have you back on the show to discuss that when it happens, when we find out.
Yeah, I'd love to be back. Yeah.
One more thing I wanted to ask you was just about, I think Canada is thinking a lot about innovation and entrepreneurship and growing our own companies and reaching out to new markets, such as Europe, for instance. And so for entrepreneurs who are starting out and they're thinking very carefully about the resources available and then thinking about, well, maybe Canadian clients to start with, or maybe, clients overseas, what are some of the things that you would encourage them to consider as they start out rather than maybe waiting, later on down the road? What would your advice be for innovators and entrepreneurs?
Absolutely, Amy. So I think first and foremost, it's simply, again, having a firm understanding of like what your organization is doing, right? And where it's doing it, and to what extent does this involve personal information, right? So really basic questions that surprisingly can be very difficult to answer, right? Because again, as we've discussed, privacy is contextual, and you will have different personas that you have to address. Like you'll have your employees, you'll have your customers, you'll have your prospective customers, and you'll have members of the public. That's minimum four. Four that you have to constantly be mindful of when it comes to understanding what your privacy obligations are. But having a firm understanding of what it is your product like is offering individuals, the extent to which it's collecting personal information, what of that information is necessary versus optional, right? And how you want to leverage it. And then understanding how that's situated within the jurisdictions in which you have to operate. That's already a lot. And that's already a really good foundation. It's a really good foundation for an organization. And I think the other one too is like, not to get too granular, but like quite frankly, having an inventory of the personal information that you're handling and the purpose for which you are handling it. If you can do that early on in your, in your desire to develop a product, that's already very, very powerful. Because when you do go to leverage the assistance of like a privacy professional, that's going to be one of the first things they ask you for.
And then what if I'm looking at working with clients, or addressing a market that has significantly more restrictive or higher or more complex privacy requirements than maybe I'm working in, right now? How important is it to think about some of those jurisdictional requirements early? And then how much of it is a moving target, really, as different countries figure it out? So even within Canada, if I'm targeting a province, or if I think I'm going to operate across, certain provinces, how do I think about those requirements? Do I need to build in the ability to meet every requirement right now? Or is some of that something that I can defer? Or do I just keep an eye on it and react in an agile way?
I think it very much depends, right? So I think if you're looking to do a cost benefit analysis of working in new jurisdictions, what I always recommend doing is having a framework of all of your legislative obligations, and not just the legislative obligations, but also like the regulatory expectations that go hand in glove with that. And create that inventory, can create that framework and have it mapped so that each of your requirements are mapped to the legislation. Because in some cases, the way that the legislation is written, they sound quite different, or they look quite different, but the requirement, in completing requirement A, you're going to be able to fulfill that across both pieces of legislation, let's say, right? And then it'll let you see sort of where the gaps are visually. Where are the gaps, and what are the things that you have to consider as part of your design if you want to go into this market, right? And some of those things can be quite onerous, right? Like when we were talking about individual rights, access and correction have been around for since PIPEDA, right? So organizations should be well versed with access and correction. Where it gets a little bit more nuanced and complex is the right to objection of processing your personal information, or the right to an explanation where you had an automated decision process being made, or the right to portability, right? All of those are supplementary design considerations that can, will obviously cost you something in order to develop it. And in having that discussion, you can actually see what your baseline obligations are and what the cost-benefit analysis is to developing that capability and then targeting that newly desired market.
It's very practical.
It
Thanks so much, Sophia.
Yeah.
That's what I love, your practical perspective on things. So one last thing, what's one thing that you're excited about, Sophia?
I'm actually really excited about this reinvigoration or this renaissance around privacy and personal information handling practices. I think like it's really interesting. I'm getting a lot more questions from just my friends and colleagues that are starting to ask, I think, a lot more nuanced and sophisticated questions related to privacy at large. And maybe as an illustrative example, I actually had dinner with a couple friends just the other night, and we were talking about this question of accuracy of personal information and information being passed on to third parties, precisely in the context of credit checks. Mm-hmm. And what happens when you realize that like these credit check bureaus have inaccurate information on you, mm-hmm. right? And how do you request that they update that information? And it's interesting because like when you start talking about how the information is being passed along and the sharing of personal information with third parties, like people's eyes kind of light up and they realize like, oh wow, this is well beyond what I had originally agreed to provide my personal information for. Mm-hmm. How can that be allowed?
Mm-hmm. Absolutely.
Yeah,
absolutely.
So it's pretty exciting to live in a time where people are starting to grapple with those questions again.
It is. Yeah. I'm so glad to hear. I'm excited too to hear that people are asking these questions and I'm asking these questions. And so I appreciate having you on the show. Sophia, really thanks so much for helping to, just have a quick peek at all these organizational struggles that are happening, because they're not straightforward conversations necessarily. They're complex and nuanced, as you say, and it's helpful to have a friendly privacy expert to talk to about these things. So thank you for joining us, and thank you for joining us on Wired for Change.